Good afternoon, everyone. Welcome to the Judicial Proceedings Committee. Today is Wednesday, February 14th, 2024. Happy Valentine's Day, everyone. We have 7 bills on the docket. We're going to start off with our Vice Chair, Senator Waldstreicher, with Senate Bill 354. We're then going to go to 438, 465, 344, 423, 447, and we'll end up with 562. Senator Waldstreicher, you're up. Would you like to bring up your panel?
Thank you, Mr. Chairman, members of the committee. Justice Brandeis called the states the laboratory of ideas, and this is a great example of that, and certainly my favorite bill this session. And so this comes from a very simple place, but results in a really significant policy that will pilot first in Montgomery County and Prince George's County. Folks can't pay their rent for lots of different reasons, but sometimes they can't pay their rent because they've lost their job, they've lost their employment, and they just need a little help. And so the question was, well, what if we just put our workforce agencies inside the courts so that folks who need help connecting with employment have it right there on the same day that they went to court regarding their failure to pay rent? And so that's all this bill does. It creates a pilot program in Montgomery and Prince George's County to allow our workforce agencies to be in rent court and provide services and connections to employment for those who need it. There are a couple amendments that council has received. The first are amendments from our judicial conference who are behind me. Those amendments are friendly. They just clarify exactly how this will work between the agency and the courts. The second amendments are from Senator Rosapep, which are also friendly and technical in nature. I just was so excited when I heard about this idea. I'm happy to pilot it in Montgomery County, and I know Senator Jackson feels the same way about Prince George's County, and I hope for a favorable report. Thank you, Mr. Chairman.
Thank you very much. We'll hear from the rest of the panel, and then we'll take questions.
Good afternoon to the committee. My name is Anthony Featherstone, and I serve as the Executive Director for WorkSource Montgomery and Montgomery County's Workforce Development Board. I'm here in support of Senate Bill 0354, Montgomery and Prince George's County Rent Course Workforce Solutions Pilot Program Bill. Many Montgomery County residents continue to struggle with unemployment, underemployment, overall inflation, and particularly the rising cost of housing. As a result, thousands of residents, which many are renters, struggle to maintain their household expenses, most notably their rent. These circumstances are further compounded now that many COVID-related emergency assistance programs are beginning to sunset. This reality for many Montgomery County residents is evident through the thousands of pending eviction cases in Montgomery County for failure to pay rent. This is why the Rent Course Workforce Solutions Pilot Program Bill is essential, as it will provide a viable resource for so many Marylanders in need of workforce development support. As the rent court process can take months, integrating workforce development services into the rent court process through the local workforce development boards can help residents directly access an array of services to help them obtain employment or enhance their current employment. In addition to employment and training services, as the lead entity for Maryland's local public workforce systems, local workforce development boards can also facilitate connections to other wraparound supports necessary to stable one's personal infrastructure. Just to name a few, the local workforce boards are closely aligned and connected with our local community action agency, Department of Health and Human Services, and various providers of basic needs within our county. We hope the committee and the General Assembly as a whole will look favorably upon this bill, as it will provide an opportunity to prevent eviction for many Prince George's and Montgomery County residents, while also providing landlords with a more stable, economically stable renter. Thank you.
Committee members, good afternoon. And I'm going to do you a favor and not replicate what my fellow colleague just said. I represent the Workforce Development Board for Prince George's County and employ Prince George's. My name is Walter Simmons. So to follow up on what was stated in our previous panelists, thousands of people are going through rent court dealing with evictions. The cases are astronomical. what you don't necessarily see in some of these statistics is that there's a lot of the same family and same household going from apartment complex to apartment complex, getting evicted and getting evicted again and getting evicted again. And that's because we aren't addressing the root cause. We aren't looking at what is causing this household to continuously be in a financial emergency, right? And what I want to highlight to you all is something that the United Way has been talking about for years, and that's the ALICE population: asset limited, income constrained, but employed. This means that in Maryland, from a 2021 study, 10% of our household are below the federal poverty level. 28% are deemed as asset limited, income constrained, that are working, that are making good money, but they can't afford to live in the high income, high housing affordability areas like Montgomery and like Prince George's. And lastly, across the entire state, 38% of our household fall into some asset limited, household constrained population. And when you look at Prince George's County, you're talking about youth poverty in 40% of our households. So this is an opportunity for us to engage these households at a point where they're most in need, but actually start providing a solution to the problem and not a Band-Aid on the issue through workforce development. We hope that we can get a favorable recommendation from this committee and the General Assembly. Thank you.
Good afternoon, Mr. Chair, members of the committee. Grayson Wiggins here on behalf of the Maryland Multi-Housing Association in full support of this legislation. In full disclosure, I also represent Employee Prince George's. We think that, well, first I want to thank Senator Wall-Striker for bringing the bill. We think it's a really good policy. We think it's an opportunity to, as Mr. Simmons mentioned, to create sustainable economic change and really, given the small fiscal impact of the bill and the large positive effect that it may have, we think it's a really good policy. I also want to thank Chief Judge Morrissey and members of the judiciary from both Prince George's and Montgomery County for meeting with us prior to the bill hearing and working out some amendments. And so with that, Mr. Chair, I'd say us too. Thank you.
All right, thank you very much, Mr. Vice Chair. Questions from the committee for this panel? All right, seeing none, thank you all very much. So that concludes the testimony for the proponents of the bill. We'll now switch to the opposition panel, and we'll hear from Chief Judge Morrissey, Lisa Johnson, and Ms. Koch.
Good afternoon, Chairman, members of the committee. To my right, I have Administrative Judge Hall Johnson, who's the Administrative Judge for Prince George's County. She oversees, that's my home county, by the way. So she oversees a staff of 274 individuals and probably more importantly, supervises 18 other judges. We joke that it's like herding, it's not, a lot of people say it's like herding cats. It's like herding lions sometimes because we have larger personalities. And to Judge Hall Johnson's right, we have Judge Koch, who is from Montgomery County, another very large jurisdiction. Both of those jurisdictions have two courthouses in them, even though their district is just one county. She oversees a staff of 206 individuals and 12 other judges. Workforce development is an important part of what the judiciary is envisioning for the future, and we've recognized that many years ago. In fact, in Baltimore City, what we call DCREP, which is the District Court Reentry Program that Judge Pastore runs, the bill has come before you in years past, and we thank you for that bill. That is basically a workforce development pilot that we have going in the city, and it's been going very well. We had some issues with the bill. We would have liked to have agreed on these things well in advance, but that's not how it works sometimes. But the good news is that we were able to work it all out. And so I was going to suggest to you, Senator Smith, that rather than oppose and support, that there's a third category of we worked it out. And we're proud to say that we did work it out today, provided the amendments are adopted that we've suggested. And Senator Wall-Striker's indicated that they are friendly. We're good. So thank you, Senator.
Excellent. Thank you very much, Chief Judge.
Do you want to say anything? I think, why don't we just, if you have any questions, we'd be happy to answer.
Worked it out, hugged it out. The love is in the air. Valentine's Day.
Happy Valentine's Day.
All right, Senator James.
I just want to thank the bill sponsor and everybody else supporting this bill for starting with a local bill. I think that is a great way to work in this arena. So I deeply appreciate it. I hope other people take note. Thank you.
All right, seeing no further questions, thank you all very much. Good to
Thank
see you all. All right. Yeah, that'll conclude the bill hearing for Senate Bill 354. We'll now move on to Senator Kelly. She's not here though, so Senator Wallstreicher, can we go Senate Bill 344?
Thank you, Mr. Chairman. This one will go fast. We heard this bill last year and voted unanimously on its behalf. It got stuck on sine die on the House side. In 38 states, they clarify that land surveyors who need to exit the property that they're on in order to do their job professionally as land surveyors have the right to do so without the threat of criminal charges. This bill simply makes us the 39th state to do that and clarifies that they are not subject to criminal charges if, for the purposes of their job, they need to step off the property that they are surveying in order to survey the property of the client. I have with me a professional land surveyor who's going to indicate why this is important. Again, I ask for your unanimous support, just like last year, for a favorable report.
Good afternoon, Mr. Chairman, members of the committee. My name is William Bauer. I represent the Maryland Society of Surveyors. Land surveyors have a professional responsibility to protect property rights of the public with accurate and impartial boundary determinations. As part of this responsibility, we are required to collect all relevant evidence when retracing a property boundary in order to understand the complex pieces of the property puzzle and to accurately identify and sometimes set the property corners as physical points on the ground. We must locate adjoining boundary evidence, which sometimes requires entering property not owned by our client. It is standard practice for field surveyors to at least knock on a neighbor's door to let them know who they work for and what they're doing. On larger linear projects, mailers are sometimes sent, sometimes by certified mail, and many times community meetings are held to engage with the affected communities prior to starting work. State and local regulations require the precise locations of adjacent environmental features and improvements on development plans. Environmental features and private utilities can have setbacks that extend onto adjacent properties. Likewise, many urban jurisdictions require the location of adjacent structures to ensure conformity of development. All of these regulations require land surveyors to enter adjoining property to provide accurate location data. Senate Bill 344 will protect land surveyors in Maryland from suits involving trespass while performing survey services. The Maryland Society of Surveyors asked this committee to make a favorable recommendation for the approval of Senate Bill 344 to allow reasonable access for land surveyors. Thank you.
Thank you, Mr. Chairman, members of the committee. Brett Leininger, here also on behalf of the Maryland Society of Land Surveyors. Legislation is not a new or novel concept. Protections provided to surveyors employed by the state and additionally by over 30 other states, which allow for a right of entry or exemption to civil or criminal trespasses. And thank you to the sponsor. And as he reiterated, this was passed out of committee and got hung up on the House side. So with that, we appreciate a favorable report.
Excellent. Thank you very much. Questions from the committee? Seeing none, thank you all.
Thanks so much.
With that, that'll end the hearing for Senate Bill 344. I see Senator Reedy is here. Is Senator Reedy here? Oh, there you go. Hey, Senator. Going to Senate Bill 438.
Mr. Chairman, can I bring up panel? Go ahead. Okay, right here. Another seat. When you can, I can come stand up here just so you know. But go stand up here. Thank you, Mr. Chairman, Mr. Vice Chair, members of the Judicial Proceedings Committee. I'm here before you today to present Senate Bill 438, which would establish in our state law and codify what the Supreme Court has ruled that a parent has a fundamental right to direct the upbringing, education, care, and welfare of their child. It also would prohibit the state from infringing on a parent's fundamental right to do so, with the protections that are provided, of course, for health and safety of a child. It is important to note that this bill does not protect just a parent's right who belongs to one particular persuasion, political party, or religious background. It would protect all parents' fundamental rights to raise their children as they see fit, protect them from systems, in community organizations, or medical professionals that would seek to impose their personal beliefs onto that person's child. Senate Bill 438, contrary to what you may see in opposition to these kinds of pieces of legislation, does not affect curriculum in schools, does not give parents authority to change entire curriculums or change entire health practices. Simply seeks to establish a parent's fundamental right to raise their child without undue interference from the state. I took note of the judiciary's letter with the opposition to the bill. And, again, thought it was interesting that they say if it's established in the Supreme Court precedent, so we don't need it in state law, then proceeded to say that it would cause all sorts of problems if we put it in state law. That's interesting to me because if it's a Supreme Court, multiple Supreme Courts have had rulings to establish the fundamental right of parents. Seems to me that if by putting it in state law, it would cause a problem, then we may have some problems we need to address. I'm joined today by a couple of witnesses who are going to give a perspective as well. We know that the impact of fathers and mothers on their children is perhaps the greatest impact anyone will ever have on you in your life. And of course, we also know, by the way, that can be a negative impact. And I recognize that standing here, that there are many times when I've discussed this issue in the community and with people who maybe both support it or don't support it, or are concerned about it, or what does it really mean? A lot of times people will talk about parents who don't do a good job, and at least in their opinion. And what I would say is one of the reasons we should establish this in law is how important it is to call parents to the highest standard, which is that they're responsible for their children. And we have, I think, a little bit of a problem like that in our culture at times, where parents almost feel like it's the school's job to do something or somebody else's job to do something. So I view this as a both rights and responsibility type bill that's focusing on making sure we enshrine in our state law the fundamental right of parents to direct the upbringing and care and nurturing of their children. But I also think it's a great statement of the responsibility that parents have. And if we can engage parents even more so than we are in our communities, we'll get better outcomes overall for everyone. So with that, Mr. Chair, I would ask for support for the bill, favorable support. Happy to answer any questions, but if we'd like to hear from our panel first, that also would be fine with me. And I appreciate your time this afternoon. Okay.
Vice Chair and Senators, thank you for hearing us today. I'm Jonathan Alexander. I'm an attorney and counsel for the Maryland Family Institute, and we support Senate Bill 438 and the proposal that it puts forward to empower, encourage, and exemplify parenting in our state. And this committee has a wonderful opportunity. As many bills are otherwise reactive or constraining, this proposal is an encouragement to one of the most sustainable institutions that any society knows, which is the institution of parenthood. I'm from Charles County, and on our street, every home is a two-parent household. There's a mother and a father. And that makes an immediate difference in any place where that family structure is prevalent. There's a 50% jump out of poverty from single-parent households to married mother and father households. There's a 60% swing from individuals that are relying on food stamps from single parent to two married parents. And there's a 25% difference from the percentage of children who experience violence in their neighborhood from two-parent households to never married single-parent households. Children in married couple families are less likely to drop out of school, and they're more likely to seek healthy relationships which mirror how they were raised. And all of this statistically happens when parents are in the home and at the helm of the decision-making. And so it's so sustainable for Maryland that we should encourage these institutions. When parents are at the helm of the decision-making for their children, it works, not only because it's natural, it's a God-given right and a responsibility there, but there are tangible results that are measurable. The individual thrives, the society thrives, In Maryland, as an entire culture thrives when parents are given the recognition and respect in law to direct the upbringing of their child. It's a right that's been recognized by the Supreme Court. It's deeply embedded in the foundations of our nation that our children are given to their parents to be known, to be protected by them without unreasonable state interference. And for those reasons, I urge you to support Senate Bill 438. Thank you.
Good afternoon. I support the Senate bill titled Fundamental Parental Rights. It seems surreal speaking before a legislative body in America about the need to recognize the irreplaceable role of parents in the lives of children against government edicts. Unfortunately, we don't have to go far to understand why this bill is necessary. In my county, at last month's Board of Education meeting, the president of the teachers union stated that they want to create what some other school boards in our state already approved, which was described as a program where selected high school students will attend a 6-week training program during the summer, where the union instructs those students on the principles of diversity, equity, and inclusion. Then those students are given leadership roles in clubs at each high school that promotes the principles they were taught. Lastly, the club meetings will be held during the school day and students will be taken out of their academic classes in order to attend. Even by the standards of America's melting pot, there are few families that have the diversity of ethnicities that exist in my immediate family. But I would never wish such a disadvantage upon a child as to have them taken out of their classes so they can attend meetings about diversity, equity, inclusion. Simply put, a child's academic success plays a larger role in their future and our society's future than the diversity of cultures and ethnicities they experience and appreciate. However, this is the danger. In our state, more than 70% of Board of Education members are the union's candidates. When it comes to our public schools, there are no checks and balances against the union's social and political views. For several years now, parents have come to boards of education around our state, oftentimes with tears, describing the loss of education and mental health issues that a number of union policies have caused, and nothing has changed, and it will be no different with this program. By next year, children will be taken out of their academic classes to attend meetings. Without this bill, that parents can come to the school board and say, no, you will not reduce my child's instruction time. There will be less children in my community being taught the skills that they and our society need. Thank you.
And sir, I'm sorry, I didn't catch your name at the beginning of the testimony.
Ethan Lowen.
Understood. Thank you. Is Mr. Hardin here? John Hardin? Okay. If not, we'll go to questions. Senator Muse.
Thank you very much, dear Senator.
Yes, sir.
I think it's a good bill. I think many times there is a thin line between education and indoctrination. And I think we want to stick at all times with education. I'm using that now as an example. So my question is, how will this work if I feel as if something that I'm teaching my child, let's just use the school system's teaching them something differently. What do I do under this bill to address that or to make sure that it's remedied?
Well, again, this bill doesn't specifically address that. What this bill would set the precedent for is we would not have school systems that could say there will be no opt-out for certain types of instruction.
Gotcha. Okay.
So right now, what you would want to do as a parent is go engage with your local school system and school board on that specific issue that is questionable. But what we are seeing is a disturbing trend where, and this is true not just in education, but even in other aspects of healthcare and other things, is if you as a parent are going against the conventional wisdom of the moment, you're quite often some places the rights being taken away to really direct that. Certainly we know that we can't have every parent micromanage exactly what their child's taught, or even exactly what they may hear from a physician or something like that. But what we want to be sure is that it's clear that the default is the parents are the ones who are ultimately accountable and ultimately able to direct that with the child.
And I agree. Good bill. Thank you. Thank you, Mr.
Thank you, Senator Sidner.
Thank you. I'm curious what, because you're giving specific examples, but this law is pretty broad reaching. Am I correct?
I would argue it's simply codifying what the Supreme Court has ruled. And by the way, not this Supreme Court either. Previous Supreme Courts have ruled that that's a fundamental right for a parent to direct the nurture and care of their child.
Would it affect our laws mandating schooling up until 18?
No, because we have a provision in the bill that does not, we're not taking away the ability of there to be a social service involvement. We're also saying you cannot, can't be harming the child. Obviously, this is not a license to harm your child.
Right, but somebody may believe that schooling is indoctrination, therefore you're harming my child.
Well, that's already happening.
I understand that. That's what that's what
Yeah,
I'm
this bill
asking.
wouldn't change that. People can homeschool their children, can choose to, I'm aware of specific examples in places where children are brought to school and oftentimes it's not often, but every once in a while, there's examples of situations where someone has kept their child out of the school system, sort of, and then they come and they,
But you don't even have to homeschool under this legislation, right?
Well, this wouldn't remove the
It says-
requirements of taking your child to school.
This
of a child
subtitle
having
applies
schooling.
to all state and local laws and ordinances, whether
Yeah.
statutory
turn it
or
over to my-
otherwise.
Let me turn it over to the actual lawyer up here.
I'll just say quickly, page 2, line 13.
Can you
Oh,
stand
yeah,
up?
sure,
They
absolutely.
like, that's okay. This is
Uh,
the judicial committee. They like to see at the rostrum.
Page 2, line 13, gives sort of the balancing power that you're looking for there. If it is a compelling government interest
Right.
of the
That's-
state to have students be in school up to age 18, then that wins out. Or, as this bill ultimately does, it allows the balance to go between these parental rights and the compelling government interest.
So would we have to go back into all our laws and meet this test for all of the laws that we currently have on the book?
Not in laws, but certainly in litigation, in a conversation where there is a controversy that comes up where a parent wants to go in one direction, the government wants to go in a separate direction. In order for the government to say that our rights trump yours as parents, they have to have a compelling government interest. So it allows parents to be on a better playing field when it comes to contentions between the government interests and the rights of the individual parents and how they want to raise their child.
So what if, so there's a balance between whether or not the individual, so there could be a balance between the interests of the individual child versus society?
That happens all the time. There are so many ways in which parents have a different perspective or a different view on how they want to raise their child versus what government is indicating.
So how does that work in the healthcare area? I mean, and I'm thinking about vaccination.
Yeah, of course, there are some individual parents that have convictions that are usually religious in nature, that they don't want to have vaccines or other interventions done to their child. And it's a balancing test between how they want to raise their child versus what the government is requiring at the time.
And it's already provided for then in under current law, right?
If it goes to litigation.
No, I mean, currently, for certain vaccinations, there are certain opt-out provisions based on religious beliefs,
Yeah,
correct?
there can be, but it wouldn't happen in the context of immediacy. It usually takes the parents saying, no, my child is leaving, we're gonna go to court, and the government saying, no, we're gonna ensure through a judge's order that this child achieves a vaccination.
So
That's when it comes to a head. This
Right.
puts parents on a better playing field if it actually comes to that situation.
So going into it, the position is my child doesn't have to be vaccinated. School thinks that the child needs to be vaccinated. And thinking about all the other children, then you're gonna have a court case and spending a bunch of money trying to make certain that the greater good is protected versus that one student.
It's the burden that governments have to meet when they want to impose something on a child that's different. And the vaccination example is obviously recent, but there's so many different examples where parents may have a different perspective on how they want to raise their child. The initial cases that brought this up were individuals of the Amish community that said our child will have instruction for a certain amount of time, but we need them to help in the field. So there's tensions with the state of Wisconsin, as it were, as to the amount of applied hours in classroom versus how much they're learning on the field next to their parents. And so there are multiple examples that we can go throughout history, but the Supreme Court, anytime that they've erred on this decision, has made it a fundamental right, recognizing the rights of parents to direct that upbringing and nurturing of their child.
How about in the area of disciplining your child? There's some people who believe in spanking and
Yes,
some
I think the
people
most
believe it's assault.
Yeah, I think the most recent case probably came out of the Supreme Judicial Court in Massachusetts. I'm not sure if there's a counterpart in Maryland, but they did say that parents have the right to corporately corporally punish their child. So they do have the ability to not spare the rod, but to correct their child.
So this bill would essentially trump our state's assault laws?
Not at all. Every criminal law, every civil law is still in place. If the government wants to make a law that says no parent is allowed to spank their child, and there have been moves towards that. If the government says that you're not allowed to spank their child, this gives parents the right to say, no, we have the opportunity in court to say we have fundamental rights to do so. And it's the government's job to say why it is necessary, narrowly tailored and necessary for the government interest for parents not to
abuse their children,
not to spank their child. It's up to your definition. But the abuse laws are still there. Malnutrition laws are still there. Every law that requires or has an eye towards parents treating their children right are still there. This is just an encouragement, as it were, to allow parents to say, well, I'm defended in my rights to raise the child how I want. It's an encouragement to raise your child the right way.
It's in the bill as well that line 18 through 20 of page 2, this subtitle does not authorize a parent of a minor child in the state to engage in conduct that is unlawful or to abuse or neglect the parent's minor child in violation of state law. So we do have that language in this bill as well.
How does that square with what's on page 1, lines 20 through 22? When this law is supposed to supersede all other state laws?
Once again, we're not saying supersede. We're saying that you're establishing the standard in state law that the default is that the parent's right in the raising of their child is the default. The state has to prove a compelling government interest. And we're adding the additional proviso that nothing in this statute would constitute being allowed to obviously abuse your child. And of course, the definition of abuse can obviously be up to, but that's why you would have to, if there was a real case about some type of, let's say, discipline or some type of, medical practice or whatever, you would obviously have to go to court. The state would have to go to court, as it often does, or as it sometimes does. I wouldn't say often, but it sometimes does. But this would just say that in cases of the state would have to prove a compelling government interest. But something like a religious practice, like their religious practices in some cultures that are very heinous about young girls, and that would be a compelling government interest that you can't. I don't want to use one specific example, but there's different things we've heard about culturally from other countries. Obviously, there's a compelling government interest. We don't want that. That's something that very easily holds up in court. But other things are not quite so clear. And so having it be very clear that a parent's right is the default, and we start from there and we move forward, I think is very important as we move ahead into a much more complex and interconnected society.
Yeah, we had a law, I think it was in 2018, 2019. I remember there being a debate about whether parents had the right to take their children to some sort of therapy if they thought that their child was homosexual. So, I mean, again, so.
Well, the state has outlawed, I think the type of therapy you're talking about, the state. So, I mean, I don't know whether they define it as therapy or not. The state has outlawed that sort of treated that sort of activity.
Right.
And
so how does that go with this?
Well, the state, if it's an illegal practice in the state, I think that would be a strong case in court. But I suppose you could bring that kind of case. Someone could bring that kind of case.
And that's why I'm kind of asking, because I'm trying to figure out how does this fit in the rubric of all of our law. I mean, again, my read was that this trumps everything. So this is the go-to. And in order to determine whether or not a law that we currently have should be the law, we have to go through this test that's listed on page 2 from lines.
If I remember that debate, the stated reason for banning that practice was it was the kinds of practices where someone is physically deprived or sensationally, I don't know how that, their senses and their physical self were deprived. And it was abusive in that way. I think that would certainly be covered under our language here. Now, would it be, hey, my son or daughter, they're undergoing, counseling at a church somewhere? I mean, that again, that would be something that would be adjudicated in courts. But again, we kind of already have that debate all the time. If you could attend a church that has or a religious group that has certain beliefs, that's something that's, I think, is a current part of debate. But Thank you.
Yeah. I think these are complicated questions and certainly if the Attorney General's office might be able to provide legal guidance in terms of supremacy of one part of the code or the other, if either of you seek that. Thank you to this panel. One more call for John Harden. All right. Seeing Mr. Harden is not here, thank you to the sponsor and thank you to the witnesses. We'll now move to the opposition of Senate Bill 438, Jeremy Browning and Lee Blinder.
Good afternoon, Chair Smith or Vice Chair Waldstreicher, the esteemed committee members. My name is Lee Blinder. I use they, them pronouns. I'm the executive director of Trans Maryland. I'm also the chair of the Maryland Commission on LGBTQI+ affairs. Trans Maryland is a multiracial, multi-gender community power building organization for Maryland's trans community. In that capacity, we work with young LGBTQI+ people all across the state, as well as their families. We understand the importance of supporting parents and students. Our students must be taught about the existence of trans and queer people to prevent harm, discrimination, and violence, to learn about how their fellow classmates, neighboring families, faculty, historical persons of note, and legislators in the betterment of our society. UNICEF, the United Nations Children's Fund, states that children are individuals. Children are neither the possessions of parents nor of the state, nor are they mere people in the making. They have equal status as members of the human family. UNICEF also states that social research shows that children's earliest experiences significantly influence their future development. The course of their development determines their contribution or cost to society over the course of their lives. What costs will cisgender and heterosexual Maryland youth charge to our society if their government yields to those who seek to remove trans and queer people from public life? We understand that fear of those who are different is a factor here, and efforts like these serve to drive a wedge to attempt to establish who can be respected in the information that is available to our young people. We are interested in an open society that allows for and celebrates a public school education, one that I also received, that includes the broadly diverse communities that make up our state. For these reasons, we urge an unfavorable report on this bill, SB 438. Thank you.
Good afternoon, Vice Chair Waldstreicher and members of the committee. My name is Jeremy Browning. I use he, him pronouns, and I'm the director of the Maryland Commission on LGBTQIA+ affairs. Thank you for the opportunity to testify today on behalf of the commission, which is in strong opposition to Senate Bill 438. The commission has extensively researched and analyzed the experiences of LGBTQIA+ youth in our state's education system, and last September, they unanimously adopted their recommendations to support LGBTQIA+ students. These recommendations include worrisome data that consistently demonstrates that Maryland's K-12 schools are frequently unsafe and hostile environments for LGBTQIA+ students. They experience alarming rates of bullying, harassment, assault, discrimination from multiple sources, including their peers, educators, administrators, and even family members. The consequences of this hostility are severe, leading to lower academic achievement, diminished mental health, and increased risk of suicidal ideation. Additionally, the presence of anti-LGBTQIA+ groups in Maryland and across the nation further exacerbates these challenges, spreading misinformation and advocating for harmful policies that endanger the well-being of LGBTQIA+ youth. In this context, Senate Bill 438 could potentially embolden such groups to undermine the efforts to support and protect queer and trans youth in our schools. Finally, all students benefit from a curriculum in our public schools that is inclusive and reflective of the diversity of individuals and families in our state. Learning about people and families different from our own promotes acceptance and celebration of our differences. For these reasons, the commission urges an unfavorable report on Senate Bill 438. Thank you.
Thank you for your testimony here today. Any questions for the opposition to the legislation? All right. Seeing no questions, that completes the hearing on Senator Reedy's Senate Bill 438. Thank you all for testifying both for and against the bill. We'll now move to Senator Kelly, if you're ready. If that works for you. Senator Kelly's Senate Bill 465. In addition to Senator Kelly, we have Lanny Hartman, Karen Strawn, Scott Wilson.
Thank you, Mr. Vice Chair, members of the committee. I really appreciate you hearing me today on Senate Bill 465. I'm all over the place today. Valentine's Day is a big day for Senator Kelly. It's all the baby-related bills in every committee. This one is not a baby-related bill. This is the Electric Vehicle Recharging Equipment Act of 2024. If you know me, you know I represent District 16, and you will probably guess immediately this is a cross file of my district mate, Chairman Corman's bill, because he has been a champion in this type of legislation. It's a follow-up bill. It's a very small bill, and it's a follow-up bill to the scintillatingly titled Electric Vehicle Recharging Equipment for Multifamily Units Act of 2021, which was sponsored by Chair Corman and Chair Gazzoni. So to refresh the memory for the members of the committee who were here and for the new folks like me, in 2021, that bill passed this committee and the Senate unanimously. As a reminder, for those of us who need the reminder, what the bill did was it really created the state policies for condo owners who want to install EV chargers in their condo parking space at their own expense. And it created those policies really identical to the process that existed for other architectural changes. So that's what passed unanimously in 2021. This is a little tweak of a follow-up, and this cross-file is on third reader in the House, but it did pass the House committee unanimously as well. So it's on third reader tomorrow. It does four very simple things. Number one, it expands the current requirements that already apply to condos to include co-ops as well. Number two, it requires the Maryland Department of Housing and Community Development to maintain information about this program on its website and to have a point of contact that can answer constituent questions on the process. Number three, it adds electric bicycles to the definition of electric vehicles at the end of the real property article. Those are the three minor changes in this bill. There's also a fourth change, which is a sponsor amendment that makes it clear that the charger owner must maintain insurance for the electric vehicle charger for the duration that it was installed, of course, at the owner's expense. That was the intention in the original bill, but I think it's just clarifying language. We have someone here who's going to discuss that amendment. So the bill is going to advance efforts to combat climate change and to reduce emissions. It's going to ensure we're not leaving out certain housing communities. Those are the co-ops. I see Senator James leaving, but I don't think you have any in your district. You're good. Perfect. I did want to make sure the committee knows Delegate Corman wants to do his due diligence. So he's checked with Hartford and also Frederick. I don't think you have any in Frederick either. There's not a lot of co-ops in the state of Maryland. So we're not including a lot of people in this, but we just really wanted to close those loopholes. I will tell you who I have here and then a couple of things about the amendments. We have Scott Wilson from the Mid-Atlantic EV Legislative Task Force here to talk to us, as well as Karen Strawn from the AG's Consumer Protection Division, Ashley Clark, who's going to discuss that amendment about insurance, and Lanny Hartman, who's an advocate for electric vehicles. There's also written testimony in your file from IBEW suggesting an amendment. Delegate Corman actually had a meeting with them today. They've come to agreement on language, but I don't have that language for you, but we will have that language. Instead of what's suggested there, what that amendment's going to do is just include some information on the website requirements that IBEW is looking for. So I will have that amendment by the time we can vote on this. With that, I would urge the committee to listen to the panelists who are the true experts on this bill and then have a favorable report. Thanks so much. Who's first? You want to go? Oh, sure.
Mr. Vice Chair, members of the committee, my name is Karen Strawn, and I'm with the Office of the Attorney General Consumer Protection Division. This bill is geared towards the way our society is moving, basically. We're moving to all electric vehicles in the future, and there are many people who have already purchased electric vehicles. They are great for the environment. The only difficulty is you need to have a place to plug them in. And this allows people who live in the cooperatives, as well as making some amendments to the Homeowners and Condominium Act to do so. I liken this to the Solar Panel Act that we put into place a number of years ago. It's just simply making this available to people, trying to keep associations from unreasonably restricting or prohibiting the use of such things. All of the costs are borne by the individual who wants to have the electric charging equipment. And so I see no downside to this. And for these reasons, we ask for a favorable report.
Good afternoon. My name is Lanny Hartman, and I'm here today to express support for Senate Bill 465. As an EV driver, I believe this legislation will bring Maryland closer to our electric vehicle goals and ensure fair access to charging. For those who want to drive an electric car, charging at home is ideal. This allows you to benefit from residential electricity rates, which are approximately 15 cents per kilowatt hour. If you enroll in EV time of use programs offered by some utilities, the cost can even be lower. However, if you don't have a single family home or off-street parking, you may have to depend on public charging stations to fill up. Relying on public charging can be inconvenient and costly. For instance, the fast charger at Walmart in Frederick charges 56 cents per kilowatt hour plus tax. This translates to being more expensive than gas. EV drivers are having to wait in long lines at some charging stations due to high demand and some chargers being out of order. Senate Bill 465 builds upon existing legislation to streamline the process for installing charging infrastructure at condos and townhouses. This will make it easier for more people to buy electric vehicles. The transition to electric vehicles in Maryland will depend on access to charging at home overnight, where it will be more convenient, cheaper, and puts less strain on the grid. Thank you, and I ask for a favorable report.
Good afternoon, Vice Chairman Walsh Stryker and committee members. My name is Ashley Clark, and I'm here on behalf of the Maryland Legislative Action Committee of the Community Associations Institute, better known as CAI. CAI represents individuals and professionals who reside in and work with community associations such as condominiums, homeowners associations, and cooperatives throughout the state of Maryland. As you've heard, we've been working diligently with Senator Kelly, as well as the House bill sponsor, Delegate and Chair Mark Corman, on this bill and its amendments. And so, as stipulated in the proposed legislation, it is imperative that the member requesting the equipment be required to provide a certificate of insurance, naming the corporation as the additional insured, reimbursing the corporation for an increased insurance premium attributable to the electric vehicle recharging equipment. While appropriate, will be difficult to define the insurance premium increase, as there are many variables and a potential increase in premiums. Keeping the insurance liability and coverage solely with the member requesting the electric vehicle recharging equipment is the most viable option. And so we are here today to stand in support and request a favorable report of SB 465 with amendments. Thank you.
Thank you, Mr. Vice Chair, members of the committee. My name is Scott Wilson. I run the Mid-Atlantic EV Legislative Task Force. I'm also on the Maryland ZVIC, Zero Emission Electric Vehicle Council, and I'm Vice President of the Electric Vehicle Association of Greater Washington, D.C. And EVADC does public education events where we take our cars out and show the public, teach them how to charge them, how to live with them. And often, I mean, many times, we hear from people that say, yeah, I would love to drive that car, but I live in an apartment, I live in a condo, can you help me? So there is a pressing need for this. And given all the multifamily housing we have in Maryland, this is a big issue. So what this bill does is it lets the HOA, I'll use that for shorthand, the HOA and the driver to cooperate to allow them to have the same sort of charging that I have as a single family homeowner. They pay for everything the way that I do. They pay for the hardware the way that I do. They pay for the electricity the way that I do. They pay for the would pay for the insurance the way that I do. And that would let these drivers to drive at 3 cents a mile the way that I do, and compared with 12 cents a mile on gas. So it would basically open up the opportunity to multifamily homeowners that I have as a single family homeowner. So the other great thing about this bill is that it sets up a clearinghouse website so that somebody can just go to the website and get all the information they need very easy. And so I recommend a favorable report. Thank you.
Thank you all for your testimony today. Senator Folden has a question.
I don't know if you want to come up, Senator. Thank you, Mr. Chair. So thanks for bringing the bill forward. I just have a couple quick questions. One is, you brought up that this was specifically geared towards the co-op.
Correct. We already passed this for condos in 2021. So this is only adding the co-ops in. It's adding the exact language that we already put in for condos into the co-ops article and the corporations and associations article.
And then in this one, is it, I guess, under that bill, is it still, are the people assigned spots then?
Yeah, it's exactly the same. So the language is really specific. It says it would go into your assigned spot or the spot that.
Yeah, I
that
mean, but are they already assigned a spot, I guess is what I'm.
You mean in a co-op, do they have assigned spots?
Yeah.
I mean, there's so few co-ops in the state, but my understanding, and I will confirm this with Chair Corman.
And then it's ran to the owner's electrical panel? Is that how that's ran, for them to pay for the power?
So the issue of the power, I'm glad that you brought that up, because this is something if you look in your bill file, there's actually a favorable with amendments from a citizen who is concerned about this as well. And I don't have the answers on this, but I had a conversation with Chair Corman right before this bill hearing, and he is going to follow up on those questions and get back to me. So I will have to put a pin in that, but I promise once I have the answers to those questions, I will come back with those answers, because there seems to be some debate, despite the fact that this is on third reader on the House floor. Someone raised sort of a late issue about how one would.
Yeah, I see where it talks about like if they take it out, and
Yeah.
obviously they're going to have to be assigned a spot that they would be able to park in, because I just don't know that it's overly clear on the part that it would be ran to that unit.
That exact unit.
Electrical
Mhm.
box. And then how does this affect renters? Is it like they?
It wouldn't. This is not rental buildings at all. Just
No,
the
I mean, if they
co-ops.
sublet, like if they rent from one of the owners, are they still entitled to that, or do they have to go through the owner?
If you're saying if that a unit owner had already put in
No.
then I don't think it would apply for renters, because it's for the co-op members.
Okay.
Yeah.
All right, thank you.
Thank you. Okay, and I will get back to you on the specifics on the electrical once we have more
thanks.
clarity on that.
Thank you. Any other questions from the committee? I have a number of questions for Ms. Clark, if Ms. Clark.
Thank you.
Thank you. And I've got a list of about 10 of them here. No, I just wanted to say thank you. We know this is your first time testifying.
It's
in front of our committee,
Grayson.
and
I know
it's your
Grayson
first
did
time,
that. He
in the
left on
General
purpose.
Assembly. So no, you did a wonderful job. and
Oh,
You're a
well,
great
thank
advocate
you.
on behalf of your client.
Thank you.
I do see Senator Charles has a question.
Oh, gosh. Yes,
A
Senator.
whole lot of questions for her. I
Uh-huh.
do. And so I'd like you to explain how you enjoyed your first time in a committee. But that's it. Thank you, Mr. Chair.
Thank you. Thank you.
All right, Senator West has a question.
It's just a comment. So time was when someone came to the committee for the first time and then submitted the questions. Every committee member would raise their hand and thoroughly intimidate the witness. We don't do that anymore.
I do have a Steve Horvath signed up to testify virtually. Is Mr. Horvath in the room? Okay, Mr. Horvath, you can unmute yourself and you're good to go.
Yeah, thank you very much, Chair and members of the committee. Steve Horvath for HOA United, that's Homeowners of America United. We connect homeowners to provide advocacy, collaboration, education, empowerment, and inspiration to create positive and transformative impacts for common interest communities. A number of our members are residents of Maryland, and some of them have spoken before your delegation this legislative session already. We support this bill with a favorable with amendment recommendation. And while we recognize this bill is first and foremost intended to extend existing protections, as you've already heard, offered to condominiums and HOAs to co-ops, there are some minor adjustments, relatively technical adjustments in a number of areas that can be made for an even greater impact. First, we encourage you to consider that all micromobility devices, including things such as scooters, would be part of your proposed legislations in addition to EVs and electric bikes. And that's simply because there are community associations across the United States that are banning these devices simply because they have a battery, regardless of the fact that some of the devices have actually been professionally tested and certified by organizations such as UL. The ones that are causing fires generally are not. Second, we would encourage you to consider EV charging legislation adopted by other states, which is largely similar to what you're adopting here and previously enacted into law, but has a few notable technical adjustments, things like statements about how you pay for the electricity. The fact that you don't necessarily need to have a separately metered connection, I think, is important because there are situations where you simply don't submeter all the EV chargers, and you can come up with solutions that work for homeowners and the communities. So we're supportive of this legislation overall. We do think there's a few tweaks, and thank you very much for hearing our testimony today.
Thank you for your virtual testimony. Any questions from the committee? All right, seeing no questions, that concludes the hearing on Senate Bill 465. Thank you, Senator. Thank you to all our advocates. As we locate Senator James and Senator Muse, who I believe are in other committees testifying on their bills, we will take Senator Folden on behalf of Frederick County Senators, Senate Bill 562.
Thank you, Mr. Chairman. Members of the committee, this is going to be the easiest bill of the day. It's a local bill, and this is, for the record, Senator William Folden, representing Legislative District 4, Frederick County. This bill is brought to you by the Frederick County Senators regarding the sheriff of Frederick County's position and salary associated with that position. It would establish a work group of 2 delegates, 2 senators, and 1 liaison from the county executive to study the sheriff's salary. And instead of, the real goal of this bill is, instead of a fixed salary, this is an attempt to attach the salary to a like law enforcement or judicial position within the state to eliminate future petitions to the state in regards to this office of sheriff's salary. So we have to stop coming back and asking for permission to increase the salary of the sheriff. So with that, I would ask for a favorable report on Senate Bill 562.
Any questions from the good senator from Frederick County? Can we attach our salary to the sheriff?
And I forgot to say, this is a local bill. Maybe I didn't. Maybe just a reminder.
And if we need a letter, please don't hesitate to give that to council.
Sure. Thank you.
We have a letter. We have confirmed on the record that we have a letter. Thank you, Senator. That concludes the hearing. That's right. So that completes the hearing for Senate Bill 562. We'll now go on to Senator James, and Senator James, take your time to get settled for Senate Bill 423.
I timed it just right to eat French fries. And Senator Kelly, I only left the room after I was sure that your bill really was a small little bill that did not infringe on issues in Harvard County. And that gave me just a few minutes to eat some French fries. The lunch of champions. Mr. Chairman, can I be joined by a panel, Bill O'Connell from the Maryland State Bar Association Real Estate Section, and Scott Boyer from the clerk of the court for Anne Arundel County. Is that all right?
Yes, so I must admit, we don't have folks signed up to testify, but they are welcome to come up and testify on behalf of the bill, of course.
All right, that's okay. This bill is a bill from last year that was voted at this committee unanimously, passed the Senate unanimously, got caught up in, the late mischief of sine die. I do want to clarify one thing. This bill has no opposition, but there is a little confusion. The bill 423, when it was dropped, did not accurately reflect a very small aspect of the bill that was brought to me by the Maryland State Bar Association. So I asked Bill Drafting to withdraw it and put this new bill in. in its place. Somehow that all got miscommunicated. So we have two bills. The other one is what's the other number? 884. So I'm going to present this bill 423, but when it's amended, it will look exactly like Bill 884. So if anybody wants to look at Bill 884, that is what 423 will look like amended. And any testimony that you have in front of you for 423 is really just asking that it be amended to look like the other bill. This is a modest proposal, and it's really going after two issues. Why is it so difficult to record land records in the state of Maryland? And how can we start to address these difficulties and make this a smoother, more transparent, uniform process? Last year, when the bill was brought to me, the Maryland State Bar Association Real Estate Section had been working for a long, long time with their members and with other stakeholders and had come to a consensus with a good bill that's going to just start the process a little bit, because there are a lot of issues in this area. And really what I just want you to think of globally is that in the area of real estate, we all know that real estate taxes are due, but outside of that, we have 24 jurisdictions with their own local governments, lots of towns. And over the years, local governments and towns have been loading up fees and assessments and connecting it to, their real estate that you own, to the point where it's like you can't sell your property until you pay this hotel tax, or you can't do it until you pay this golf tax or water and sewer, which makes some sense. So it is kind of grown in a very tentacle octopus kind of way, but with no uniformity, consistency in how this is communicated to the people involved when they're doing a real estate transaction. So what happens is you go to closing, the people that involved in the closing have gone as best they can to the clerks, to the different towns. They've said, tell us what we're owed because we want to get this all done at closing. Some people are some entities and local government very diligent. They tell you exactly what is owed. You make accommodations in your settlement sheet, but not casting any aspersions, but lots of other local governments or towns just are not able to provide that information consistently and accurately. So you go to closing and you find out that some little fee hasn't been paid. So you're in a sort of an untenable situation. Either the people engaged in the transaction get left holding the bag and, somebody suddenly you're a collection agency, or they try to go after some poor homeowner who's, doesn't have any money, or the new buyer doesn't have any money. So that's just not a way to run a railroad. Since in the end, by closing day, everyone does know what's owed, because finally everyone is paying attention. What the bill does, it's written technically, what the bill does is just say, listen, 45 days ahead of that closing, we will pay you $55 to get a certificate, which means everybody did their job, gave the accurate information, what is owed anywhere in that county. It's all well documented and it's paid. And we know it's paid, or we know that what is owed, so that when you go to real estate closing, you know what's owed is paid, and there's no loose strings or all the hassle and problems that fall after that. So that's a layman's way to describe the bill. And I have, the head of the real estate division of the Maryland State Bar and a clerk of the court from Anne Arundel County. And like I said, there's no opposition, and I hope I did it justice. And I'll stop now and see if the committee has any questions of me or the panel that's with me.
So I'm sorry, would you like the panel to testify, or they're here to answer any questions?
If you all don't have any questions, and if you all don't have any problems with the bill you passed unanimously last year, I think they're here just for informational purposes and don't need to testify because it's Valentine's Day.
That sounds
right?
wise. Yes.
This
Senator
is my
West.
Valentine to the committee.
That's exactly right. We appreciate it.
Wow.
Thank you, Mr. Chair. I have a question, actually, Mr. O'Connell, and it's not so much about this bill, but about a closely related matter. So back when I was an active practitioner of law and occasionally would record documents in the land records, the documents, I'd go to the court's office, or someone from my office would take the documents there, pay the fee, and the documents would be taken by the clerk and would end up sitting on a clerk's desk for days, weeks, in some cases, months, not being actually recorded, but the money had been paid to record them, but they're sitting there. And I always thought mischief could occur. Someone could come in and try to buy the house from the new owner, and the documents, since they weren't recorded, would not be immediately apparent to people who want to deal with the real estate. Has that problem been taken care of, or is that still a problem that we need to take care of through legislation down here?
So I want to be sensitive to the fact that it's Valentine's Day and that we have a big panel on another bill. So if this isn't directly related to the legislation, perhaps you guys could talk in the antechamber. Would that be appropriate?
Sure, that'd be
Okay.
fine.
And all I would say to Center West is, as I indicated in the bill, there are a lot of problems. And that this group has been working diligently on this. And I think you've hit the nail on the head with another problem, but this bill is just address this one problem right immediately. Thank you.
Thank you so much. And thank you everyone on behalf of this bill. That completes the hearing for Senate Bill 423. And next we'll move to our final bill. Senator Muse, if you are ready and take your time to get set up, we'll move over to Senate Bill 447, Residential Owners in Common Ownership Communities Bill of Rights.
Is he here? Okay. All of the virtual. Okay, great. Thank you. Thank you, Mr. Chairman, and members of the greatest committee here. For the record, I'm C. Anthony Muse, and I'm here to support SB 477. I did have a panel. I thought Steve Horvath was here, and Alex, I think we have online, Alex.
So Alex and Steve, I believe, are online.
Both of them are
Yeah,
online. Okay,
yeah.
I'm sorry, misunderstood. Okay, this bill will create a bill of rights for residential owners in a common ownership community, whether it's an HOA, condo, owners association, or cooperative housing corporation. So SB 447 will provide protections for the homeowners by promoting transparency, and it would improve the communication between the HOAs and the homeowners. This bill would also require the office of the Maryland Attorney General, the Consumer Protection Division, to enforce actions on behalf of the residential owners. The state of Maryland has several Bill of Rights. This is not new. They have several Bill of Rights laws already in place. Some include State Correctional Officers Bill of Rights, Law Enforcement Bill of Rights, Property Owners Bill of Rights. So establishing a Bill of Rights for residential owners in a common ownership community would not be foreign to the state. And Alex, who you'll hear from in a moment, who was a member of the 2005 Task Force on Common Ownership Communities, is here or is online today, and he can speak in detail about the importance of establishing these Bill of Rights to protect our constituents. I'll turn it over to him, but I do want to urge a favorable report on this important legislation.
Thank you, Senator. We'll go ahead and Mr. Gamian. I apologize if I'm pronouncing that incorrectly. I'm sensitive. I've got a tough last name as well.
It's Hakimian. Yes. Good afternoon. My name is Alex Hakimian, a longtime resident of Columbia, and I'm president of my townhouse association in Columbia. I wholeheartedly support this bill. I wish I could have testified in person today, but thankfully I can testify virtually, and I appreciate that. I want to thank Senator Muse for introducing this very important bill, because the time has come to establish a Bill of Rights for residential owners of common ownership communities, just as the General Assembly has done for other segments of society in Maryland. The State Task Force on Common Ownership Communities that I served on has advocated for a Bill of Rights here in our state. Nationally, there's a Uniform Law Commission that has advocated for it nationally for every state in the United States. So this has a lot of backing amongst a lot of very prestigious groups. One of the rights I want to focus on would strengthen the Attorney General's authority to enforce our state's common ownership community laws. This is so important because if there is an association that violates an HOA law, then according to our existing law, the Attorney General's office, and I read from the HOA law, the Homeowners Association law, that the violation shall be within the scope of the enforcement duties and powers of the Division of Consumer Protection of the Office of the Attorney General. Well, when someone tries to use that provision to file a complaint against an association, currently what the practice is for the Attorney General's office to ask for mediation. Well, the problem with mediation is that one party can say, no, we don't want mediate. And then the Attorney General's office goes ahead and cancels the case. So what this bill does is to strengthen the authority for the Attorney General's office to actually enforce the law when it comes to these committee associations. And I want to thank you, and I ask for a favorable report.
Appreciate it. Thank you for your testimony. Next, we'll go to Patricia Thomas. Ms. Thomas, you're up. Oh, it looks like we may have lost Ms. Thomas.
Can you hear me?
Give us 1 second to get you back.
Oh, thank you.
Please go ahead.
Can you hear me now?
Yes, we can hear you. Please
Okay,
go ahead
I don't know why you can't see me, but I'm ready to go forward.
We can see you. We've got you.
Okay.
We're ready for you.
All right, thank you so much. This is a great opportunity, and I'd like to thank Senator Muse for really leading the charge in the Senate with this, and I'd like to thank the chair and vice chair of Judicial Proceedings and all the other members. I'm testifying in support of SB 0447 because the process of democracy is one of change. Our laws are not frozen into immutable form. They are constantly in the process of revision in response to the needs of a changing society. Having lived in a condo HOA community for 20 years and served on the boards for 2 terms, I can attest to the need for protection and support. The rights of owners are not taken into consideration when financial obligations are planned. Boards of directors do not have the right to cause financial chaos for the residents. This is occurring too often in many communities. Should you have to sell your home to pay a special assessment that has not been voted on by the community? If the community asks for another proposal that will satisfy the financial needs of the community and the board says no, because they don't want to reconsider their plan. When this occurs, who helps the homeowner? We need due process and equal protection. There are so many bills that protect cats, dogs, rivers and streams, insurance companies, developers, roads and streets, but not us, condo and HOA communities. The 14th Amendment states, nor shall any state deprive any person of life, liberty, or property without due process of law, nor deny to any person within its jurisdiction the equal protection of the laws. We cannot continue to be labeled as private without support from our local and state government. The time is now to make this right. We have truly been left behind. I thank you, and I am really hoping we will get your favorable opinion of this bill.
Thank you so much for your testimony. We'll now move on to Sheila Daniels Henriquez.
Thank you. Thank you for this opportunity to testify in favor of in favor of Senate Bill 447. Being a board of director and having witnessed firsthand the challenges, discrepancies, inequalities, retaliations, harassments, disadvantages, hardships, unfair treatment, lack of knowledge of laws, unfair treatment, financial losses facing unit owners and common ownership communities, I do understand why there's an imperative need for Senate Bill 0447. This bill addresses imperative issues facing common ownership owners. In addition, I believe it will support and benefit the state of Maryland. Here are a few reasons why. Homeowners and their governing bodies, board of directors, will have access to the resources and support they need from their state office, which will assist in utilizing their understanding of their rights and responsibilities, therefore allowing them to be effective board of directors and homeowners within their communities. In relation to boards and community managers, it assures a more comprehensive understanding of their rights and responsibilities, as well as productive training and accountability. I can honestly say from experience that training and certification can have a positive impact on anyone's professionalism, knowledge, responsibilities, and when it doesn't, because one chooses not to adhere to the law, then an official state office can be an enforceable, powerful, positive assurance that one is corrected. This should be true for common ownership, governing bodies, and community management as well, for they make decisions on behalf of common ownership communities. This includes making decisions with common ownership community funds. Please take note that Montgomery County has a CCOC office for over a decade, and the cost is only $10 per year per homeowner. Thank you.
Thank you so much. We'll now move to Mr. Horvath.
Yes, thank you, Chair and members of the committee. Steve Horvath again for HOA United. The concept of this Bill of Rights is great, and this has been supported for over a decade by the Nonpartisan Uniform Law Commission, which you heard Mr. Hickman testify to earlier. Community associations and their homeowners absolutely need reasonable remedies within reach. As evidenced by a government-run survey, the only one I've actually seen recently or possibly ever in Colorado over the past 6 months, where over 1,600 professionals and homeowners provided feedback, and half of those homeowners are unsatisfied with their community association. Very unlike what you see in other industry-sponsored surveys that provide a very different figure. This bill is one step in the right direction, and it will require the Maryland legislature to pass additional, more precise legislation to realize the protections it espouses. Maryland has a great opportunity to enact reasonable homeowner protections by adopting regulation commensurate with the role of community associations to act as powerful, hyperlocal, quasi-governmental entities. You can improve the balance between reasonable homeowner expectations and the responsibilities of community associations to promote more affordable, dependable, and sustainable homeownership with a favorable recommendation on this legislation. Thank you for hearing my testimony.
Thank you. Do we have Mr. Lyons in the Zoom room?
Yes, there.
Okay. Mr. Lyons, go ahead. We are ready for you.
Yes, thank you very much for this opportunity. And I apologize, I have to go to my notes that I want to share with everyone. So based on website data from the Community Association Institute, approximately 1.1 million Marylanders live in 500,000 homes in more than 7,000 common ownership communities. These residents pay nearly $2 billion a year to maintain their communities. By 2040, the common ownership community housing model is expected to become the most common form of housing. This last statement foretells the need for SB 0447. Common ownership communities are mostly self-governed, closed communities that lack limited oversight or enforcement authority from state agencies. A 20-year review of Maryland court cases filed by homeowners has shown a reluctance by the courts to impose injunctive relief on community association board decisions, making fair enforcement of association covenants, controls, and restrictions challenging to attain. Bias in community association governance is further difficult for homeowners to pursue, as there is no affordable and accessible venue to litigate such disputes, other than a costly, litigious, and complex court system, which most homeowners can't afford. For nearly 20% of the Maryland population, the set of regulations that most immediately governs their daily lives, homes, properties, and even pets do not stem from any local, state, or federal government, but are instead generated, administered, interpreted, and executed by a community association. Community associations certainly have their merits, but many just make up rules with the only reason being to generate more revenue and impose their will on homeowners. This legislation will not prevent this from continuing. However, it will provide a level playing field and equip the homeowner with resources as effective as those of the community association. I've asked for a favorable report, and you can see by all of the interest in this, we really need it, senators. So I'm hoping for the best.
Thank you so much. That completes the hearing for the virtual testimony and the sponsor. Let's pause there. We do have one in person. I know we went a little bit reverse here. Do we have any questions for the sponsor or for any of our virtual testimony? Senator James.
Yes, thank you. To anybody, I suppose, maybe the sponsor first. Did some incident or event bring you to wanting to file this bill? And could you share just a little bit of what that event was, if any?
I'll let others who may feel that you want to answer. I don't know the exact incident.
Hello.
Can you answer that?
Yeah, if one person virtually would like to kind of talk about
just
the root of this bill.
Yes.
Whoever would like to volunteer.
Alex.
I would like to volunteer.
So I'm being told, I think Alex would like to kind of.
Oh, yeah.
Mr. Hakimian. All right, we're seeing if we can locate Mr. Hakimian. Okay, he has left, so.
We can follow up.
Okay.
Let's have him follow up and give us a scenario of circumstances of what's driving this.
Perfect.
Thank you, Mr. Chairman.
Wonderful. And then in person, we have Mr. Enton, who I believe is not here today, and Ms. Strawn. Ms. Strawn, come on up.
Mr. Vice Chair, members of the committee, once again, my name is Karen Strawn, and I'm with the Maryland Office of the Attorney General in the Consumer Protection Division. Let me start by saying we support a Bill of Rights on behalf of individuals living in common ownership communities. We are simply seeking an amendment, and that amendment has to do with the provision that asks for individual actions on behalf of individuals living in common ownership communities by the Office of the Attorney General. The Office of the Attorney General does not represent individuals. It represents the state of Maryland and citizens residing in the state of Maryland. And we work hard to try and bring as many actions as we can on behalf of as many different people when we find that there's an unfair or deceptive trade practice that's occurring. We have brought actions on behalf of people living in associations when there's been unfair and deceptive trade practices that have occurred, and we will continue to do that. The concern is bringing individual actions. There is a fiscal note attached. To be honest with you, it's quite conservative. It probably would require more than what the fiscal note says, but we've indicated what it says. But more importantly, we need to look at this from an aspect of fairness. If an individual lives in an apartment complex, they are not entitled to an individual action by the Office of the Attorney General. And we receive many more complaints from people who rent apartments than we receive from people who live in common ownership communities. It should not be simply a basis that you live in a common ownership community should allow you to get that direct action. It's rather, it would make more sense if it was something that had to do with the economic levels and individuals have. And for those reasons, we ask for an amendment to this bill to remove that provision.
Okay, thank you. And we have that in writing. Any questions for Ms. Strawn? All right, seeing no questions, that completes the bill hearing on Senate Bill 447. And that completes our bill hearings for today. There's lots of people to thank for short bill hearings, including yourselves. But if we could all thank Sandy Pop, who scheduled today's hearing so that we could all be home with our loved ones. Thank you, Ms. Pop.